I have the privilege of introducing Judge Ralph K. Winter. I think one of the great things of having me introduce him and to have him as the speaker, it is because I less objectively think he graduated from and taught at the greatest law school in the country. And certainly the fact that he is here and that I am introducing him shows that the rumor about law school education at Yale Law School being solely social engineering has to be wrong. Judge Winter began his term as a United States Circuit Court judge in the Second Circuit in 1982. He had been, as I said, a professor at Yale Law School before that. He had served a few years before that, when he was a little younger, as law clerk to Chief Judge Caleb M. Wright of the United States District Court in Delaware, and to Judge Thurgood Marshall in the U.S. Court of Appeals in the Second Circuit. Judge Winter has served as a member of the Judicial Conference Advisory Committee on Civil Rules, and in 1993 he was appointed chair of the Judicial Conference Advisory Committee on the Rules of Evidence. He was a senior fellow with the Brookings Institute from 1968 to 1970, and an adjunct scholar with the American Enterprise Institute from 72 to 81. He received both his BA and, as I said before, his law degree from Yale. We have a treat in store, as those who previously heard Judge Winter. I can't say he's always right, because indeed just a couple of weeks ago he denied me relief from the bench, but he's mostly right. Judge Winter.
It's always a pleasure to be asked to speak to the Federalist Society. Some of the older time members say it's a broken record, but I can remember a day when the entire membership of the Federalist Society was in my office at the Yale Law School, and there were chairs left over. I'm glad this is the most interesting conference there's ever been, and Jerry, maybe Jerry should have quit while he was ahead. I have a speech here that is based on a conversation I had with Leonard Leo, and he then gave it a title. Before I left, there was one of those intimate exchanges between spouses that occur, and my wife said, "Is your speech any good?" And I said, "Well, yeah, it's a great speech, but they'll hate it." And she said, "Why will they hate it?" And I said, "Well, I say a lot in there that attacks lawyering as an industry." And she said, "Can't you ever play to the crowd?" Anyway, the title was, I believe, "Meaningful Change in Our Civil Justice System. Is the Defense Bar a Problem?" It turns out that not having seen the title, I nevertheless began with the line, "Meaningful change in our civil justice system will not be easily accomplished." And one reason has to do with the incentives of the bar in shaping that system. Those desiring reform tend to view the plaintiff's bar and control of bar associations by ideologues as the principal source of opposition to reform. Some years ago, however, Judge Silberman wrote an article entitled, "Will Lawyering Strangle Democratic Capitalism?" The article pointed out that it is the entire profession and not a parochial segment that has an economic interest in the proliferation of legal rules and complex legal proceedings. The jury, as it were, is still out on whether democratic capitalism will die gasping for air under the weight of litigation. However, time may be proving Judge Silberman right on the mark in perceiving lawyers as a group that presses its self-interest in shaping our legal system. I was struck last night by John Stossel referring to the lawyering industry as part of the market and the market working. I think that's not entirely wrong, but mostly wrong. The demand for lawyers is not governed by a market where consumers may exercise free choice, that is, as to whether to use lawyers at all. Rather, the demand for lawyers is the result of government. And lawyers have every reason to understand that. That being the case, the result of being a nation where lawyers play a major role in government is there for all to see. For example, some legal rules seem to exist solely because lawyers profit from them. Civil RICO provides trouble damages and attorney's fees in cases that never involve actual racketeering or organized crime. With predicate acts alleged under the broad definition of mail fraud developed in the criminal law, where enforcement is limited by the exercise of prosecutorial discretion and the resources available. Civil RICO is now routinely a source of federal jurisdiction in what would otherwise be routine state law claims. Any dispute over a contract that requires periodic performance or communication between the parties can support allegations of a pattern of racketeering activity involving misleading statements or failures to inform. Indeed, the first civil RICO case to reach the Supreme Court of the United States was a garden variety breach of contract action. One result of civil RICO, therefore, is that its treble damages and attorney's fees provisions have partially displaced ancient common law rules concerning damages for breach of contract. This is truly a bizarre result, suggesting even that in enacting RICO, Congress believed that Hadley against Baxendale was the work of La Cosa Nostra. It is instructive that only a powerful group, like the securities industry, has gotten political relief, and that may turn out to be only partial relief from civil RICO. Otherwise, civil RICO is alive and well, threatening the less powerful, such as ordinary individual proprietors in the construction business and so forth, although its sole reason for existence seems to be to profit lawyers. So too, there is considerable evidence that derivative and class actions in the corporate area profit lawyers while imposing a net loss on investors, the very class they are supposed to protect. Even the most favorable studies suggest that in a large number of such cases, investors receive no benefit while paying the legal fees of all parties. In other cases, wealth is transferred from one group of investors to another, and the first group of investors also pays all legal fees. In yet other cases, some investors benefit, but the benefit comes from insurance that most sizable corporations purchase. The insurance also pays all legal fees, because the cost of the insurance, which investors must ultimately bear, must cover all amounts paid in settlement, judgments, and fees. Investors overall have a net loss. Even in the small number of cases in which there is a net return to investors, the settlement may be at best only roughly related to the merits of the underlying claims, leading to the overcompensation of weak claims and the undercompensation of strong claims. The only constant is the benefit reaped by the plaintiffs and defendants' lawyers. It is thus a misperception to single out plaintiffs' lawyers or lawyers with particular ideological beliefs as having the sole incentive to provide political support for unnecessary and inefficient rules of law that increase the cost of litigation. This is a somewhat unusual misperception in that it comes from sources that understand economic incentives in the political and economic marketplace and expect that an industry will act politically to maximize returns to that industry. The fact is that the economic incentives of defense lawyers regarding rules that proliferate litigation do not significantly differ from those of plaintiffs' lawyers. Lawyers as a group including the defense bar, have an interest in maximizing the demand for legal services. This is particularly the case at a time when practitioners must deal with the high cost of support services, the instability in law firms, and the understandably increasing restlessness of clients. Because the demand for legal services is affected by the nature of substantive and procedural rules, reforms in those rules that seek to reduce the cost of litigation will often be met by powerful opposition from the lawyering industry, including lawyers whose clients might be aided by the reforms. Members of the defense bar may not always be vocal in opposing reform, but they are not likely to make a real effort on behalf of reform if the result will be to reduce the demand for their services. Indeed, the defense bar sometimes openly opposes measures that seem promising methods of reducing litigating costs to their clients. A couple of years ago, proposals were made to limit contingency fees in personal injury cases to that portion of a settlement or judgment to which the plaintiff's lawyer had added value. One proposal was to give a defendant in a personal injury case an opportunity to respond to an early demand for a settlement offer. If the offer was accepted, the plaintiff's counsel's fees would be capped at 10% of the first $100,000 and 5% of any greater amounts. If rejected, contingency fees could later be charged only against net recoveries in excess of the offer. Moreover, the plaintiff's demand for settlement would have to be accompanied by basic, routinely discoverable information to allow the defendant to evaluate the claim. Now, I don't know whether this was a good proposal or a bad proposal, but the thing that struck me about it was that it was attacked by some members of the defense bar. Although I see nothing in it that would compel their clients to make an offer of settlement or otherwise to weaken their case. It's difficult to see how any of the defense bar's clients could have been adversely affected. The opposition from this quarter seems peculiar in that the defense bar does not generally oppose caps on contingency fees. And one can speculate only, and some of those who made this proposal have stated it openly, that what really troubled the critics was that the proposal would have given plaintiffs and defendants great incentive to reach an early settlement without incurring substantial legal bills. Similarly, the defense bar gives abstract support to the need to find ways to reduce the large, not to say scandalous, resources that go into civil discovery, but will mount ferocious and often unprincipled opposition to concrete measures that would actually reduce that cost. I'll speak at length on this because I was a member of the Advisory Committee on Civil Rules when that committee took up complaints about excessive discovery, which I at least perceived as coming from defendants and their lawyers. To briefly go over it, over the course of several years, the committee discussed the problem, and in its judgment, one partial remedy would be to identify those discoverable items that any competent lawyer would immediately request and that any competent judge would order disclosed. If such materials had to be provided automatically at the beginning of litigation, the committee thought the costs of formal requests and often frivolous opposition would be eliminated and a quick start on the case would be made. The committee proposed an amendment requiring the disclosure the names of witnesses and locations and categories of documents, quote, likely to bear significantly on any claim or defense, unquote. I favored the general venture of looking for ways to reduce discovery costs, but I had great doubts about this particular proposal and indeed voted against it. I believe I was the only member of the committee, but this was in an early stage and it was sent out for comment. I thought it was just entirely too ambiguous. When the proposal went out for comment, criticism quickly appeared in great quantity. There was an organized campaign that sent the committee a barrage of letters and presented oral testimony from lawyers throughout the country. Although the lawyers were widely separated geographically, many of the letters used virtually identical language. I have nothing wrong with this method of lobbying so long as the person signing the letter verifies the merits of the criticism that has been provided for retransmission. Disturbingly, many of the correspondents had not done that. We received a large number of letters and heard oral testimony asserting the entirely false claim that privileged or work product materials would have to be automatically disclosed under the proposed rule. In fact, under every version of the proposal, it specifically allowed parties to assert and get a ruling on a work product or privilege claim before materials subject to such a claim needed to be disclosed. In part, however, I thought the criticism was entirely well taken. As drafted, it seemed to require disclosure of all materials relevant to any legal theory that an answer or complaint might support. If a party failed to anticipate a legal theory of its adversary, the disclosure might be deemed inadequate and violate the rule. Moreover, as proposed, the rule would cause a party to alert the adversary to legal theories of which it was ignorant. And this is all quite beyond the other problems of the expectation that the discovery might be massive and for little purpose and so forth. After receiving the commentary, the committee revised the proposal to require automatic disclosure only of materials that were, quote, relevant to disputed facts alleged with particularity in the pleadings, unquote. This language was taken from Rule 9b and had a body of case law interpreting it. Under the revised rule, a general, as I understand it, a general allegation that a product injured a person through a design defect would not trigger any disclosure because it doesn't involve facts alleged with particularity, but it's just conclusory. On the other hand, an allegation that a railroad crossing at a particular location was unattended and that the plaintiff's car was struck by a particular Amtrak locomotive at 2:15 on July whatever would trigger disclosure. Now, of course, there's an inevitable area of ambiguity, but no more than the irreducible ambiguity that dogs any rule. And sure, there will be judges who will come down with decisions that don't seem right. I would suggest that the present rules with those same judges would lead to exactly the same result, but only after a lot of papers have been filed. And so the committee regarded it in good faith as having responded to the criticism. No one had to disclose anything. No one had to concern themselves about what the other side's legal theories were. If there was a fact that was alleged, you could move under Rule 12F to strike it as irrelevant, and so forth. It just did meet, I thought, most of the legitimate criticism, and as did others. Nevertheless, the outrage of the bar continued. One charge that I perhaps don't understand and therefore will make some light of it, is that the rule would interfere with the relationship between attorneys and clients. This was based on the premise that a legal obligation to disclose unhelpful, not to say negative, materials should not be imposed because lawyers don't want to have to tell their clients that they have an obligation to disclose it. That's a very peculiar view of the role of a lawyer. I got to say that it seems to posit that a would-be Willie Sutton's lawyer should not have to tell him that he had an obligation not to rob banks, because that would interfere with their attorney-client relationship. Now, once the bank was robbed and Willie Sutton was convicted, then it's okay. The argument also reflected the notion that one that troubled me, that the attorney-client relationship is enhanced by charging substantial sums to a client for the fruitless defense of a result for discovery resulting in an inevitable order of disclosure. Indeed, it seemed to me the very argument that costless but useless proceedings are desirable is in itself an admission that wasteful civil discovery routinely occurs, largely for the benefit of lawyers. Finally, it was charged that automatic disclosure was inconsistent with the adversary system. In fact, however, most discovery in the criminal law area is in the nature of automatic disclosure. In particular, the obligation of the government to disclose exculpatory material to the defendant. Just recently, the Judicial Conference of the United States killed a proposal that would have introduced limited formal discovery in criminal law like civil discovery. It wouldn't be nearly as extensive, but would still be formal discovery. And as I said, the conference killed this, and to my knowledge, no one argued to the conference that we have to have formal discovery because it's necessary to make criminal proceedings adversarial. Quite apart from these arguments with which I disagree, and I may be wrong. These were arguments that numerous people, including Justices Scalia and Thomas, to one degree or another, bought, and that's fine. Maybe they're right. But several of the critics continue to attack the original and discarded proposal, even though it had been redrafted. At a symposium on procedure, I encountered an executive of a drug company who was organizing opposition to the rule, but had not been informed that the rule had been rewritten. Articles appeared that simply ignored the new language. Moreover, some of these articles and some of the critics continued to assert that the rule purported to eliminate the attorney-client privilege and work product immunity. The most troubling thing, however, was what did not appear. There were calls not to move too rashly, although I've been studied for years and so forth, and all that. But what did not appear was any rebuttal to the argument that costly proceedings should not attend disclosure of materials that any competent lawyer will ask for and any competent judge will grant. No constructive alternatives that would reduce the costs of civil discovery were offered, nor was the status quo defended. It was just that anything that would change it was denounced. In watching this entirely misleading debate unfold, I became convinced that the defense bar's failure to address the merits was in part a strategy to mislead its clients, as well as to persuade the Congress to reject the rule. For all of the protests by the defense bar, the plaintiff's bar also was not enthusiastic about the proposal. One of the groups that joined in Erwin Griswold's brief to the justices in considering the rule was joined by a Nader civil litigation group. From conversation with plaintiffs' lawyers and from some remarks quoted in the press, I gather that many in the plaintiffs' bar did not share the view that the amendments to Rule 26 disadvantaged defendants. They viewed automatic disclosure as a device that might expose weaknesses in their case before they had had an opportunity for discovery. I'm in no position to judge whether they were right or wrong, but the widely held view that defendants would be terribly disadvantaged was simply not shared by all the plaintiffs' groups. And I want to emphasize, I don't mean to say that automatic disclosure or that rule is a panacea, may not be misused, can't be approved upon, that there aren't legitimate arguments against it, and maybe it was even a mistake. I don't say any of those things. Indeed, I once described the thing in print as barely non-trivial. I understand it can be described, I think, as positive. There are a lot of places that don't use it. There are some places in which it's in the rules, but the lawyers don't use it, which can be because they're ignorant of it, they don't like it on principle, or they'd rather bill the clients. A preliminary draft, I understand, of a survey under the Biden bill indicates that where automatic disclosure has been used, there hasn't been a feared increase in satellite litigation. Judges with experience with it, 85% are said to favor some form of continued automatic disclosure. The attorneys with experience, I'm told, some 60% want some form to continue. Nevertheless, I think further discovery reform may well be dead. I had thought that as a first step, automatic disclosure might come, and then there'd be a rule saying that all further discovery would be by leave of court, that you could not just go on these enormous fishing expeditions. But I think further discovery reform is a corpse with a contagious disease. Who killed it, I don't know. If the lawyers killed it, it was the perfect crime because they left their client's fingerprints on the body. I have described this controversy, one, because I was familiar with it, and again, the most skeptical person involved in this whole venture. But also, I think it illustrates the enormous political difficulties any reform that lessens the cost of litigation will encounter. Many of the areas where reform have been suggested, like discovery, are really central to the profit centers and that are at the heart of the staffing and organization of law firms. With many mouths to feed, those who run firms necessarily view with great disquiet proposals that might disrupt their business, might disrupt their way of life, and might disrupt their standard of living. Not only are these firms powerful institutions, but they're run by persons of influence and persons of great ability and great learning. They are also the principal source of information to clients as to how reforms will affect them. It is to be expected that any proposal that reduces the cost of litigation to clients will be portrayed by some as disadvantaging the clients in litigation and increasing the amounts in judgments and settlements to be paid. As to some changes, that portrayal may well be entirely accurate. But at least in my view, the history of Rule 26 suggests that often it will not. So the principal organized constituency for reform is partially disabled by having access only to flawed information, while the ultimate beneficiary, the public, is diffuse and disinterested. And I think reformers face a long, lonely road even in getting the attention of those whose self-interest lies in reform. Thank you.